We're back for another episode of Unilateral Decisions. Thank you so much for joining us. As we touched on in the last episode, the world of collegiate athletics has shifted dramatically over the last several years. And that did not start with name, image, and likeness. It's been a slow-moving target for decades, so before we can really dissect professional athletes returning to college, eligibility lawsuits, or broken NIL contracts, we need to go further into how we got here. So today we're focusing on the 2014-15 case of O'Bannon versus the NCAA. And it all really ties back to something many of us enjoyed and have fond memories of growing up: video games. All right, we're back with another episode of Unilateral Decisions. This time we're talking Ed O'Bannon versus the NCAA, Mike Walsh, Sam Ehrlich, Joe Nickell, myself, Dominic Shelden. But I want to start off where this all began, video games. Do you guys know the name of the first college football video game and what year it came out?
Oh, that had to be a Bill Walsh game.
Yeah, really putting on the spot, us on the spot there. I have no idea. I think
90s?
Bill Walsh is, football, rings some bells. Probably early 90s, late 80s.
This is a great guess. Mike Walsh, not a family member of
No
Bill
relation.
Walsh, no relation. You are correct. Bill Walsh, college football, June of 1993. That eventually turns into the beloved NCAA football game. And for those that were too old to play the video game, those that were too young to experience it prior to the modern day iteration, what did college football, the video game, look like in the 90s, early 2000s?
Well, I do think that as we get into kind of the name, image, and likeness component of video games, in the early 90s, mid 90s, it wasn't nearly as much of a concern. We didn't have the likeness concerns when you're talking about the graphical interface of the game back then. But certainly being able to kind of know who you're playing with, and that's the draw, right? I mean, that's the draw of the NFL games. It's the draw of any of the pro games. It's the same thing with the college games. You can play as a school all you want, but to really get into the granular detail and play as the player that you're watching on TV, I think is what sets it apart. And I think that's really what spears this whole conversation.
Yeah, I feel like I have a different relationship with the NCAA football games than other people. I love career mode. I love recruiting. So after a couple of years, it doesn't necessarily even matter who's really on the team. But I still love the feeling of being able to play with the actual players that are on the field. I still think that's a really cool experience, and I know it's such a great experience for everyone else. So, like when the NCAA pulled the license, in 2015, kind of in response to the O'Bannon, Hart, and Keller lawsuits. There's a reason why the game never kind of came back until after the NIL era, because that was just such a big part of the game and such an essential part of the game. And yeah, I think even for someone like me who loved getting those generic players out there as quickly as possible through recruiting, still a really important aspect to it.
Joe, walk me through the money that came in from this game, and then that's where it all starts. There's so much money being made. I don't know how accurate it was. I saw an estimate that was $3.4 billion per year with NCAA football prior to the new iteration that came back several years ago. So all this money is being made, focusing on student athletes, colleges, the experience at those game day locations. Where does all that money go? How much of it was actually getting funneled to schools, if much at all?
Well, Mike could probably have a better idea on this, and so correct me if I'm wrong, but most of it was going to CLC, and then the money that was going to CLC was getting distributed to the schools.
Yeah, I also don't want to miss the fact that it's expensive to make video games.
Yeah, 100%.
So there's a huge component to that. But yes, when it comes to the schools, it funnels through CLC or whoever their licensing organization is, and often what they would do is they would tier the schools and how much money the schools were due based on their historical performance or any other reasons why somebody would often choose them to play. So actually Boise State, because of on-field performance, but also because of the blue turf, people using the blue turf in the game, there was kind of this bonus where it was like you get put into this different tier based on how frequently people think you use you in the game. But mostly on-field performance.
I just remember being a student assistant. Like we talk about how the game progressed over time. Like I was a student assistant at Washington State. And one of my first jobs that they'd given me as a student assistant was to take the rendering that EA had sent Washington State and literally to go out into the stadium, look around, and see how accurate the depiction of the stadium was. So it was very, very granular.
Yeah.
So that leads us to this O'Bannon case. Ed O'Bannon played UCLA basketball in the 90s, and he sees himself essentially in one of these video games, right? Similar number, similar size, similar skill set, and he's wondering why they're using him and he's not getting paid. So walk me through, Sam, first, the initial O'Bannon challenge. Why did he bring this forward years after he was done playing?
Yeah, so actually, it's important to remember there are actually 3 lawsuits kind of in kind of the same fact pattern. We had the O'Bannon lawsuit, which was kind of the third head of, and really, even consolidated with one of the other 2 cases. But at the same time, or before that, in fact, we had decisions before that in the cases involving Sam Keller, who was a former quarterback at Arizona State, and Ryan Hart, who was a quarterback at Rutgers. Those 2 had filed lawsuits based on right of publicity. They had filed lawsuits saying, my intellectual property rights are being violated because you're putting me into this game without my consent. I mean, there's all the paperwork that they filled out with the NCAA, but how binding was that? And EA had tried to come back with a First Amendment defense saying, we have a right to kind of essentially, make games based on real life events, real life kind of things, and
public domain kind of.
Not exactly public domain, because it wasn't something that would have hit the public domain. Right of publicity rights are forever, even after you die. But First Amendment free speech kind of arguments, saying like given that these are kind of these public events and these kind of publics, these public figures, we have a right to essentially do reporting on it, even if it's not reporting. And the Ninth Circuit and the Third Circuit, Ninth Circuit and Keller, Third Circuit and Hart, wholly rejected these arguments. They said it goes beyond for the First Amendment, given how commercial the use is, and that yes, these players do have a right of publicity. They do have kind of their right to their name, image, and likeness, even though, as I think many of us may remember, at that point, and even by the point where Keller and Hart were filing these lawsuits, they didn't have the names on the back of the jerseys. It was just QB number 7 or something like that. But it was still what they looked like. They still kind of had their models. It still had kind of their playing styles, whether they were a mobile quarterback or a pocket quarterback. They still had their height and weight, their facial features, all these different things to kind of try to make it as realistic as possible while trying to toe the legal line. And clearly it didn't work. So we had the Keller and Hart lawsuits, both of them, going in favor of the players. But the O'Bannon lawsuit was a little bit different because the O'Bannon lawsuit was based on antitrust law. It was the idea that, to put it very, very bluntly and very kind of simply, the idea that the NCAA, along with EA, was price fixing the cost of these players' name and likeness at $0 by not allowing, by the NCAA and all the member institutions coming together to say, you can't make money off of this, even though we're making money off of it. The players argued, and I think as we all know at this point, successfully argued that in a free market, without these artificial restraints, they would have been able to get paid by CLC, get paid by EA for their name and likeness. And in fact, EA actually, brought in testimony, or there's testimony from EA executives saying, yeah, no, we would have paid the players if we'd given the chance. And recent events have borne that out.
It's such a unique thing. I mean, you mentioned it, but you had, I don't know what the correct term would be. I wasn't that into gaming, but a patch of some sort where you could download something, right? So you could almost immediately, with a click of a button, get your favorite players' names on those uniforms. And so it essentially establishes that they're worth more than $1 or worth more than $0.
Yeah.
But how do we get to what that becomes? Why does that set the stage for future discussions?
And it really did for a lot of different reasons. And I think the biggest one is this was really, like, there had been other losses suffered by the NCAA in kind of similar cases. But in terms of player-led cases, in terms of cases where players were suing the NCAA over essentially a subset of their amateurism rules, this was really the first time we had seen players win these cases. I mean, O'Bannon really... It was kind of a shocking decision, one that the NCAA was very upset with, and justifiably so, because there have been so many of these other lawsuits where, for a variety of different reasons, the NCAA had been giving, the ample latitude that, that came from Board of Regents and came from that language. And the Ninth Circuit took a very different approach here. They said, well, we're not really sure that Board of Regents really prescribed this, this surface level ample latitude, this surface level deference to the NCAA's amateurism rules. We're not really sure that the Supreme Court intended to create just a blanket exemption for the NCAA's amateurism rules, and we're not going to follow it because we think, one, quite a bit has changed since 1984. The O'Bannon lawsuit, decided at the district court in 2014 and at the Court of Appeals in 2015. A lot has changed since 1984, but also that wasn't necessarily the focus of the Board of Regents lawsuit in the first place. It's something that, we in the law call dicta, which is to say, non-binding, kind of just an aside and, not really kind of relevant to the actual precedent of the case. And ultimately that's, the Ninth Circuit agreed with the district court in that, and they really did a lot to kind of pick at and rebut some of the other cases that had gone the NCAA's way and kind of similar, not quite similar fact patterns, but like eligibility lawsuits and stuff like that, where they said, we just don't agree with these other courts that the NCAA deserves this level of latitude and this level of deference. And that was a major, major blow to the NCAA.
I think one of the interesting things about O'Bannon, you mentioned it, is very narrow in scope, right? And it was about price fixing. It wasn't taking on the philosophical belief of amateurism or, any moral ground of whether or not you could or should pay athletes, but by kind of chipping away at the underlying, legal components of like paying them zero for something that clearly has market and commercial value, you start to undermine the whole theory of amateurism. And what does amateurism mean? How is it defined? What does it mean to the NCAA? What does it mean to the people who care about the NCAA? Because that's always been an argument, right? Is if you take away that, then we're going to lose the favor and people aren't going to care as much because we'll just be professional sports. But when you started to say, oh, O'Bannon's not challenging this based on how people feel about it, it's getting challenged based on the fact that there's a very clear law that you set this price at zero and the market dictates otherwise, and you didn't even allow these people whose price is set to zero to participate in that decision. And so I guess, was O'Bannon different in that way? You mentioned the other two lawsuits, but was it different in the way that it approached that?
Yes and no. And that's kind of the funny thing, because you're saying it's not like, the O'Bannon lawsuit, it's not like the Ninth Circuit was really challenging the idea of amateurism overall and in the first place. And in fact, quite the opposite, because the district court had, as part of the injunction, Judge Claudia Wilken, whose name will come up in future episodes, Judge Claudia Wilken had actually included not just a prohibition on the NCAA, or not just money damages, I should say, but she also gave an injunction. She also gave the players an injunction requiring the NCAA to allow schools to pay up to $5,000 in a trust payable at the end of their college careers to compensate them for their NIL. And the Ninth Circuit reversed that. The Ninth Circuit said, we don't think this is appropriate because the NCAA is an amateurism enterprise. And they talked about how there's a big difference between having, allowing them to, or kind of allowing kind of these ancillary benefits, allowing for educational benefits, and O'Bannon would lead to cost of living for players. But they said there's a big difference between that and paying them directly. And that there's a clear line in the sand here, that it's a quantum leap, to use the exact phrasing in the Ninth Circuit, between giving them educational related benefits and paying them directly. And they were not ready to bridge that gap there. So that's why they overturned that $5,000. And in fact, the plaintiffs, both parties, actually appealed to the Supreme Court. The Supreme Court wasn't interested in hearing the case, but it is interesting that the plaintiffs actually had their own appeal of the O'Bannon lawsuit as well, even though they had won. But because of that kind of still lingering deference to the NCAA.
Yeah, it's interesting, though. It just cracks the door. I mean, you even mentioned it, educationally related benefits. We determined that 5 years later. Direct payments, we determined that another 5 years later. I mean, that O'Bannon cracked the door on all this.
It did.
But we're now in modern day, and the same premise of the O'Bannon case is going on right now.
Yes.
It's not capped at zero anymore, but they've capped it again without any sort of collective bargaining.
Yeah, and there are a lot of parallels to O'Bannon with kind of what we're looking at with the House settlement. House settlement, of course, caps NIL compensation directly from the schools at $20.5 million, kind of raising every year that the House settlement is going on. And there's been a lot of talk about whether that's also an illegal price fix as well. It's one where the players can't necessarily challenge. It's a little complex, but I think kind of the general understanding is that they wouldn't be able to challenge it because it's part of a settlement that they, they have agreed to release claims based on kind of items in the settlement. But doesn't insulate them from outside actors. It doesn't insulate the settlement from outside actors like collectives or other third parties who are looking to, pay players. Or attorneys general, who've seen get involved in these cases in the past few years. It'll be interesting to see how that goes and whether or not kind of similar takeaways as O'Bannon are applied in those cases as well.
Amateurism, which is at the heart of all of this, is such a moving target. I don't even know how I would describe college athletics amateurism today. So
It's part of the problem.
Where do we sit with amateurism, and does it vary sport to sport?
I think it does. I think it really does. And it's also interesting to note because federal judges have the exact same position on amateurism that you do, Dom. I mean, the Supreme Court in Alston, kind of copied language from the district court opinion in Alston, talking about how the idea of amateurism has become a moving target because it just changes from year to year when, just between, and a lot of that you can't necessarily blame the NCAA for because they, I'm sure, would have preferred not to allow cost of living or NIL or these various different things because they were forced to by court decisions or state legislation in the case of NIL. But really just the amount of benefits that have been given to athletes over the years have increased and kind of gotten farther away from kind of this ideal of amateurism. And trying to pin down exactly what amateurism means, it's something where Judge Wilkin in the Alston decision, to a certain extent in the O'Bannon decision as well, just really kind of picked at the idea that there's any kind of clear definition of amateurism because the NCAA just hasn't really been able to. And, and I know we're jumping ahead to our Alston episode here, but even looking at the Alston concurrence, by Justice Kavanaugh, he talked about the circular argument of amateurism. College athletes are amateurs because they're not paid, and they're not paid because they're amateurs. That's essentially what the NCAA argument boils down to, according to a sitting Supreme Court justice. So I think it does vary from sport to sport. I think you have distinct differences in how the sports are treated in those regards, but I think it's to the NCAA's great, harm. It's really hurt their legal strategy over the years because they don't have and really can't have a consistent definition of amateurism.
There are differences. So like you take soccer versus golf, for instance. A soccer player is permitted through NIL guidelines to, provide training. And the governing body of soccer does not prohibit that. But golf, the USGA, they're permitted through NIL to go provide training. But the second they're getting paid to train other golfers, that makes them a professional. And once they're a professional, they lose amateur status. And once they lose amateur status, they lose college eligibility. That's one sport. I think the USGA has defined it well. Whether or not everybody agrees with, that model in the current climate of name, image, and likeness, that's a different argument. But
and whether it's defensible,
right? But that's the rule right now. Mm-hmm. So that's while current soccer players can go get paid to train golfers. There's a different manner in which they'd have to do it.
So riddle me this then, as the resident golf expert, someone who's been to Augusta National, tell me why that is unacceptable from amateurism status with golf in college, but you can have a bunch of NIL deals that pay you money. So how are you amateur in part of your life, but professional in another part of your life for that specific sport?
Well, I'm not too deep into the weeds on this, but my understanding is it's to protect the professionals. Like if you're a professional golfer, whether you're, a touring professional or, somebody with a card, local pro, it's to protect them. They are the experts, the professionals in that space. And once you start getting paid to train somebody, that makes you a professional. And once you lose your amateur status, like you can't compete in amateur tournaments. There are professional PGA Tour members that have played on the PGA Tour that have gone back and tried to drop back down and get their amateur status back. And there's a moratorium and all these other rules and regulations, but it's not unheard of for that to be the case, to get you back into competing at the amateur level. And it's funny because we're talking about college athletics, but there's big debates when that happens too. Like somebody who's played and earned money on the PGA Tour having not played for years, wanting to come back and, well, now I'm an amateur, and there's, all sorts of debate going on around that.
Sounds like an exclusionary market to me. Though I will say it's significantly harder to sue the PGA Tour for antitrust because you'd have to go Section 2 of the Sherman Act instead of Section 1 because, the funny thing about the NCAA is at schools. It's a collection of these various different institutions that are coming together to create these rules, similar to how courts have treated professional sports. It's kind of the variety of different teams. So Section 1 of the Sherman Act, which is, contracts, combinations, or conspiracies between two or more parties, generally easier to prove than a monopoly, which is what you'd have to go after the PGA Tour with, because they're only one entity instead of a group of different entities coming together to create these kind of exclusionary rules. Just an aside.
Well, I mean, this kind of leads into, a question I have. I mean, we talk about collective bargaining, and that is kind of the phrase everybody uses when, how are we going to fix this? We're going to collectively bargain, with the student athletes. And I would love to have that conversation as well and how that works. But legitimate question, if the professional sports leagues themselves start to define amateurism similar to what the USGA has done for golf, does that provide a pathway for the NCAA to be, the entity in which amateur sports are played? That's like what all of this arguing by the NCAA is to protect its amateur status. So if the NFL, the NBA, WNBA, NWSL, like if they follow a similar model, and maybe they have some rules in place that I'm just completely unaware of them, but if they follow a similar model as the USGA and say, this is what amateurism is, and if you are doing some of these things that no longer classify you as an amateur, and once you're no longer an amateur, you can't compete in college, does that provide a separate pathway forward than collective bargaining? So
if I'm understanding you correctly, and I want to make sure that I'm kind of understanding your hypothetical here, if say say the NFL were to take in kind of college football, and they were the NFLPA were to take in college football players, and as part of the NFL collective bargaining agreement had kind of a professional and amateur with kind of two separate rules for them, where the amateurs had to stay amateurs. They had transfer restrictions. They had all these different things. Is that kind of what you're asking about here?
I don't know if we're talking about football, I don't know if collegiate football players would have to be under the NFLPA model. I mean,
that's kind of why I'm asking, because in order for it gets a little complicated because we have the Claret decision, which throws some wrinkle into that, and it would really kind of be an interesting fact pattern in terms of kind of applying Claret to that situation, but. Generally speaking, you would probably have to have some relationship between the NFLPA and these college players in order to bind the college players to the collective bargaining agreement and have the provisions in the collective bargaining agreement apply to them. Claret, and what I'm referring to with Claret, Maurice Claret, running back for Ohio State back in the early 2000s, who filed an antitrust lawsuit challenging the NFL's age rule. He wanted to. You have to play college football for 3 years, or you have to be 3 years out of high school. He wanted to leave after his sophomore season, and he filed a lawsuit trying to get into the draft. And the Second Circuit Court of Appeals said, no, this is covered by the collective bargaining agreement. Even though you're not part of the NFLPA yet, you are seeking to try to be. So therefore, the collective bargaining agreement as an entry rule applies to you. But here it wouldn't quite be that, because it's not necessarily an entry rule. It's something that is really kind of divvying out. And I see a lot of parallels, to example, for the minor league baseball system. Not quite the same because we have that pesky baseball exemption, but the Major League Baseball Players Association recently took in all the minor league baseball players and created a new minor league baseball collective bargaining agreement. My understanding is you probably have to do the same thing. You wouldn't necessarily be able to have an NFL collective bargaining agreement that also defined rules for college sports without including the college athletes as part of that union.
I want to go back to a real basic question. The concept of amateurism, to me, has always been doing something for no money. When I was in college and I worked in a kitchen, I was a professional sous chef because I was getting paid to be a sous chef. I was not an amateur sous chef that did it for fun. So how can you get paid for an activity, a job, and it be amateur at all? Like, am I missing the boat here? Because it's clearly not. If you're getting paid to do something, you're no longer an amateur.
Yes and no. There are existing rules even in other professional organizations that allow for amateur status. We talk about tennis. Mm-hmm. You can keep your travel expenses. You can keep up to some amount of winnings. There's different things that have been established. And so that, I think, is the parallel that with the NCAA, it's not even just monetary, it's what is compensation. And if you're getting the scholarship check, forget cost of attendance and all the stipends and everything else, purely your tuition, that's compensation, right? And so where do you draw the line? And the challenge for the NCAA was the line shifting and it being, a line in the sand that gets washed away every time there's a challenge. And so when you move it and move it and move it, and you still try to make the argument that amateurism is our defining characteristic and what makes us different, but you can't define amateurism, that argument kind of goes out the window. And eventually it's like, well, people are going to stop watching if players make anything. They're going to stop watching if they make more than a scholarship check. They're going to stop watching if they make more than a scholarship check and cost of attendance. And none of that's true. It's proven not to be true yet. So, who knows where that line actually is? And we may find it one day. I mean, the O'Bannon, decision contemplated that, right? Very distinctly.
Very
in 10
so.
years here, we're still seeing it. We're still seeing that bear out in real life. But I do think that that's interesting that they acknowledged that 10 years ago or 11 years ago now. But to your question, the amateurism piece, it's not hard and fast, unfortunately. It's not volunteer versus paid. It really does kind of have its own niche, and to this point, every organizing body kind of gets to define it itself. There's no universal decision of amateurism, probably because there's different nuances there's not a scholarship in every organization. There's not, right? So you kind of get to pick and choose what you want to be true of your organization. But the challenge for the NCAA is that they have picked and chosen multiple times and still tried to make the argument that this is the thing that makes us different. And yet every time you change that thing, it hasn't really made you different. So,
well, and you're talking about, student athletes being treated similarly to other student body, members of the student body, right? Like a student athlete's going to get tutoring, but that's available to other students on campus, right? Like I think that's going to the heart of what you were getting at. But until NIL, the tuba player, in the marching band could give tuba lessons to somebody and get paid for it, but I couldn't hire a soccer player to train my daughter. So even though they were trying to say these rules are the same and this is what classifies as an amateur, like that, it wasn't the same. Like it bore out all over the place.
The grievances we could go into with this system, I think we could be here for hours. So we want to put a bow on it. We'll finish with our unilateral decision. And it's a bit vague, but at the heart of this, does the concept of amateurism in college athletics even matter anymore? And if so, how would you choose to define it? Moving forward, if you get to make all the rules.
So I've resisted to this point in our previous question about going full academic and being like, well, amateurism, the word amateurism is just a social construct. So, you can define it however, our society defines it, but I'm not going to do it any more than I just did. I think the whole idea of amateurism is something that it's this idealistic type thing. It's just, it's just kind of like, we like to think about it as kind of this, golden ideal. But it's also fair to question whether it was ever a thing. I think Mike put absolutely nailed it by talking about how, well, they've been getting scholarships, they've been getting tutoring, they've been getting all these different things as compensation for playing as a college athlete. And I don't know how you can argue otherwise. Like this is directly, as compensation for being a college athlete, where, as the Third Circuit Court of Appeals in Johnson, drilled the NCAA on in the employment law case, the Johnson case. If you stop playing college sports, those benefits go away. It is clearly that compensatory relationship. So was amateurism actually ever really a thing? I'm not even sure it was. And again, getting into the super academic, what exactly does amateurism mean? How do we classify what amateurism means? But I think there's a lot of parallels to what we're going through with college sports right now to what the Olympics has already gone through. because the Olympics used to be an amateur organization as well that had similar, very restrictive kind of measures to ensure that all their athletes were amateur. And that went away, in the 80s because it made more sense, because we want to have the dream team being able to play in the Olympics. It's nice to have, those super teams. And I feel like with college sports, we're kind of going through a similar reckoning here, where it's what makes more sense. Does it make sense to have kind of these very restrictive kind of amateurism restrictions that are being shown as illegal, or do we have to kind of move the waters, and to extent, like, where do we draw the line? Where exactly do we define what our product is and how our product is different than professional sports?
And that's where I think enter this conversation about, there is a way. I think the amateurism component to it, I think, is probably on its way out. And if I were in charge, I would stop referring to it that way. I'd stop that being the messaging and the narrative. And I'm a person who used that narrative for a long time. I'm not saying that it's always been, bogus, but the courts have proven us recently that that's just really not the definition. That's not the word. That's not the way to describe it. I think, and we've seen this, there's been some contemplative, messaging out there about this from some people that I know I respect, about maybe defining it as college sports and finding a way to truly define that to where that is differentiated from professional sports. And I think there's a lot of already built-in advantages to being able to do that. There's a lot of, I think we have some proof, even a few years into NIL now, that people care about the logo for the school.
Absolutely.
And it's not purely just because this player is really good at what they do that this person cares. And I do think there's a lot of proof to that. And I think we can talk about that in future episodes. But I think there is an avenue to explore college sports as like the differentiating factor, the thing that makes you different, the thing that is unique in the market. And there's going to be ways to do that. And I think that eligibility is one of the first things that we're going to approach in that realm, where it's like, okay, if you just stop trying to say, well, you're not eligible because you're not an amateur, but there's no way to define amateur, then at least maybe we can find a way to say, look, eligibility stops for college sports at X and Y point. And we can all agree on that, because this is what college sports is. And I think that it's easier said than done. And there's a lot of legal challenges to it right now. I'm not saying it's an overnight thing, but if I were making the rules and making the strategic decisions about the roadmap of where this thing's going, I would abandon the amateurism argument and I would change the narrative and the framing to try to say, this is actually what makes us different. It's not that they're amateurs, it's that they are college athletes. And we'll define that together here moving forward.
Yeah, at the end of the day, I think we have an affinity for a school, for a program, and that's going to continue no matter how this is branded. I love my school. I want to watch them compete. I want to watch them be successful, but they want a level playing field, the rules to be the same across the board, and those rules that are just continuously getting challenged. Like, we need to go back to the drawing board and figure out what this is going to be, for the next era of college athletics.
And also, let's not forget that for the vast majority of the athletes, the educational component is still hugely important and a huge differentiating factor. And so, again, that has nothing to do with amateurism. You can be an amateur without any sort of educational benefit, but if we can tie that to college, university, whatever, I think that can get us back to some of the heart of the things that are a differentiating factor.
Yeah, and there's a lot of value to college sports staying as college sports. I mean, even from the perspective of, as a student, it's cool to have the star football player in your class. It kind of gives you that connection to this team that you don't have with the professionals. Even as a professor, it's cool to have these athletes in my classes and to follow how these athletes are doing. And you don't get that with professional sports. That could be a differentiating factor. I think defining the eligibility rules is going to be an enduring challenge, as the 50 plus lawsuits over eligibility rules have made very perfectly clear. But I do think there's a way to establish the pro-competitive benefits of an eligibility rule that is explicitly tied to being a college athlete, to being a college student while you're playing sports, even if you're making all this money, and have that be legally defensible. It's just a question of finding that line and kind of in a way negotiating that line with the courts or Congress.
We're only 2 episodes in. So far, the NCAA appears to be a villain. I think that will shift a little bit as we continue to get to modern day. But stay tuned. Next episode, we are talking Alston versus NCAA. Not another huge success for the NCAA, but we'll get into that next episode. Thank you for watching and listening to another episode of Unilateral Decisions.